Welcome to another episode of Pinsky Law Presents. Today's episode, the Freedom of Information Law and the Open Meetings Law as it pertains to fire district fire departments, is going to be a clip of our 2020 Fire District Commissioner training, where we regularly train between 120 and 150 fire district commissioners over our 2-day Fire District Commissioner training in order to fulfill the 6-hour training component required by law. Here's a clip from our 2020 conference. Open Meetings Law. Now, this could be a very long discussion. I try not to make it too long of a discussion. It is not complicated in abstract, but its application is very complicated. There's a lot of rules and regulations, and people who know this tend to know it. I just, on behalf of the Finger Lakes Regional EMS Council and REMAC, this is all public information, so I can say it, just had a whole freedom of information dispute. Somebody saying, you have to do certain things. And I said, that's not what the law says. And so the Committee on Open Government, a New York State committee who interprets the Freedom of Information Law, wrote an opinion and said, yeah, you're right, you don't have to do this stuff. But people know this stuff and will harass you. And here's the point why this is important before I get into it. If you refuse to comply with a valid FOIL request, they can sue you. Right? Now, previously, no lawyer would ever handle this because what's your damages? Except that the law was amended maybe a decade-ish ago, I think in, I forget, 07 maybe, but to say if you lose as an agency, you have to pay the citizen who sued you, you have to pay their legal fees. I love handling these suits now because I can tell you right away whether you should be complying or not, right? And I've definitely, told people, look, I'm more than happy to sue a town or a village for you if they're not complying, but normally it takes a phone call to the village attorney and saying, come on, what are you doing, right? Do you really want to do this? But this is complicated stuff. Okay, so let's look at it. Recording meetings. You do not need to record meetings. I am not, and we're not going to get into the COVID stuff. I am not going to give you a temporary law or a lecture on temporary law, which is going to go away, right, hopefully soon. So we're not going to deal with COVID. These are the existing laws that will survive COVID. And yes, we will absolutely survive COVID, I promise you. Just don't leave New York State. So you do not have to record meetings. But should you record a meeting? If I'm the secretary, I want to record a meeting. If I'm a commissioner, I want you to record a meeting. Why? So you get the words right. So you get the resolutions right. Now, I will tell you, and again, I'm going to go through resolutions in the format for them, but we suck at resolutions. So your resolutions, yeah, we should buy some turnout gear. That's not a resolution, right? You can't just be so flippant with your words, say we're going to buy turnout gear. You need some good wording. You need to write a good resolution, something with some legal binding language, not just buy some stuff. But if you record the meetings, then we can really get this is what you said. So I think you should record the meetings. I also think you should have a policy, and the policy will say we're going to record the meetings, but the recording will be destroyed once the minutes are approved. You don't want to have to keep the recording forever. Now, you can get a gazillion terabyte hard drive now to keep recordings of meetings forever. I mean, this whole weekend is being recorded now onto these, and I could probably record years more of them. I mean, it's amazing, and this is a little disk. It's amazing what you can hold, but I don't want to maintain that in the files. It takes too much room and too much effort to maintain it in files. So your policy should say destroy it after the minutes are approved. And if there's a discussion at the minutes, right, what should we be, what did we say? I didn't say that. Yes, you did. That wasn't the motion. Yes, it was. Good, let's go back to the tape, right? And then you destroy it. The only exception is you can't destroy anything that's been requested. So you may get that citizen who did this to me, or my district, and start knowing that they're recording for the benefit of the secretary, would hand in a FOIL request every meeting, don't destroy this, I want a copy. Also, they provide a copy, and then you destroy it. Okay, Open Meetings Law. A lot of words. Let me just sum it up for you as we do. The Open Meetings Law is not about just recording your votes. It's about recording what you said and why you said it. In other words, the public has the right to know not just what you voted on, but what you said in support of it. So those of you who have secret meetings, and we will talk about those meetings now, soon, those of you who have secret meetings outside, walk in and say, motion to buy $1.3 million aerial truck. Yes, 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 and yes. Well, how the hell did that happen so quickly, right? How did you get to the point that you were able so quickly to make that, right, $1.3 million purchase? And I will say you had secret meetings, right? You had secret meetings. You can't do that. Generally speaking, the public has the right to see your deliberations. So you need to let them see that. That's what all this language sees. Every meeting where a quorum is present is open to the public. Now, we're going to have some fun discussion on this, but every meeting where a quorum is present, and a quorum, generally speaking, except possibly for joint fire districts who can have up to 7, but usually don't, a quorum is 3. So if you have 3 commissioners in a room, even if you're 6 foot socially distanced, you are having a quorum, right? You may not talk about district business. But that raises some interesting questions. Now, by the way, let me just tell you notice of meetings. This is important, secretaries. You have to give public notice of the time and place of every fire district meeting. Normally, after your organizational meeting, you're going to say, attention public in the newspaper, right? We meet the second Tuesday of every month from 7 to whenever. And that's enough. But if you change your meeting, change the date, or you add a meeting, and by the way, work sessions are meetings. Work sessions are meetings. Work sessions are nothing special. They're really called special meetings. Then you need to advertise those. Some districts do 2 meetings a year. The second's a work session. I don't know what that really means. All that means is it's another meeting where we're going to discuss stuff, right? But your public has to get notice of the meeting. How much notice? Well, if you have a meeting that is scheduled at least 1 week prior, you knew about the meeting at least 1 week prior, you have to give at least 72 hours notice. I will talk about what notice for a moment. Every other meeting that you knew less than a week in advance is you give as much notice as possible, right? As much notice as possible. At a minimum on both ends. You send a notice to the media. What's the media? I don't know. They don't tell us. Media is newsprint. Media is radio. Could be social media, I suppose. Could be your television station. You send a notice. Ideally, email or fax it to the official receipt line of that whoever. Are they going to do anything with it? Probably not. Probably not, right? So it's not great notice. If you have a signboard, put it on your sign. If you can give it to the town. By the way, giving something to the town on their signboard is the best. If you have a post office in your territory, give it to the post office. But you should try to put it in many places as you can. Put it on the front door of the fire district. If you have a big sign, lit sign, or lettered sign outside, put it on there. As much notice as you can give. But the general rule, 1 week is, if you know a week in advance, it's 72 hours notice. I like faxing things to the media because you have a fax or an email confirmation. If they don't publish it, it doesn't matter. And most importantly, this says you give notice. This does not say you publish notice. You do not have to pay for your meeting notice to be published. It does not have to go in the legal notice section. There are some exceptions to that. Your lawyer will tell that later. We may or may not cover it, but you do not, regular meetings, work sessions, whatever, special meetings, they do not have to be paid to publish. Make sense? Okay. To have an executive session, executive sessions have to be at a meeting that was publicized. You cannot say, well, look, we know we're going to go into executive session anyway, so we didn't tell anybody. The public has a right to see you sit down and meet, have a motion to go into an executive session, state the exact and specific reason, which we're going to cover, for the executive session, and then you can go in executive session or tell the public to leave. And then when you come back in, you come out of executive. By the way, don't have a motion to come out of executive session. You'll see why in a minute. Everybody, I moved to come out of executive. That actually messes you up. And I'll show you why in a moment. But you then go back into public, and then you take whatever action you take. You can only have executive session for certain reasons. Not many of them apply to a fire district. Matters which will impair the public safety if disclosed. I don't know, if you have a terrorist in your organization, do you want to talk about it? I don't know what that could be. Any matter which may disclose the identity of a law enforcement agent or informer. I can make some stuff up, but how often does that happen? Information relating to current or future investigation or prosecution of a criminal offense, which would imperil law enforcement if disclosed. Again, not so common, but here are the more common ones. Discussions regarding proposed, pending, or current litigation. Guys, I think we're going to get sued, right? Or we should be careful, whatever, right? We want to have a private meeting discussing that. That's fine. Collective negotiations, collective bargaining negotiations, if you had a union, that can also be in private. And then the big one, you call this personnel information. Stop saying that. The courts have held that's not a legally sufficient reason to be stated. You can, however, quote medical, financial, credit, employment history of a person or a corporation, matters leading to the employment, promotion, more likely, demotion, discipline, or suspension, or dismissal, or removal of a person, right? What you call personnel matters, that's not enough. You have to say disciplinary matters. Personnel matters is not enough, and your minutes have to reflect the reason you go into executive. Preparation, grading, or exams, you don't have that, or buying or selling property, right? And this is the one the guy went to jail for. Go to executive session and, right, you want to keep it confidential, right? You don't want people to know how much we're going to bid on property or sell it for. And mere regurgitation of the statutory language isn't enough, right? So that's why just saying personnel matters doesn't work. Discipline of a volunteer is sufficient. Do you have to say their name? I'd prefer you didn't, right? I'd prefer you didn't. I don't think you have to be that specific. So, rules. You cannot vote to spend money in executive session. You can approve bid specs, maybe, but I wouldn't. You'll see in a minute. But you cannot vote to spend money. If you vote in executive session, the minutes are then public. So listen to that. If you vote in executive session, you then have to take minutes that become public. So why did I say do not vote to come out of executive session? You just made the minutes of that meeting public, right? So don't do that. Just come out. All minutes of executive sessions have formal votes. We voted on the following, so if you're going to do that. But again, the only thing you can't do is vote to spend money. There's no reason to be voting in executive session, right? I generally wouldn't. Why? Because the minutes are going to be public. Now, if you have something where you don't want to be in the building that you're voting on, this has happened, you want to get out of there before it becomes public what you did, then I could see it, right? I can't think of a lot of reasons for that, but I could see it, and I've had instances of that. But it's going to become public a week or 2 weeks later anyway. You have to disclose the minutes if a vote is taken, right? So once again, do not vote to come out of executive session because you just made the minutes public. Okay, let's talk about minutes, secretaries. This is really important for you. Again, I talked about what has to be in it, so we've already had that discussion. Minutes have to be taken at all open meetings, right? Not necessarily executive meetings, and has to consist of certain things, which we talked about already. Here's the format you use. Upon motion made, seconded, and discussion held, the following resolution was approved by the commissioners. That's always your same language. Now, I think you should say who made the motion and seconded it. I don't know that you have to say it, but I think you should say it. Why? I don't know. I just think it's good practice. But you absolutely must, by law, by statute, identify the commissioners' names and how they voted. Yes, no, abstain, absent, right? You must do that. So upon motion made, seconded, discussion held, the following resolution was approved by the commissioners. That language is always the same. Be it resolved to purchase a fire apparatus in the amount of $1.3 million from so-and-so, subject to whatever, right? That's what you do. I told you that if somebody's aggrieved, they can go to court. If they think you violated the open meetings law, they can go to court, and they can get your attorney's fees if you fight that, if you lose on this. And if you unintentionally fail to comply, then that might not be grounds alone for overturning, but it could be grounds. Now, if you intentionally try to hide your meeting from the public, the court will overturn the action you took. You don't want to be in that position. No. But, I like when you ask questions so I can drink. Let me explain my answer to that in more detail. So the question is this: if all the commissioners are present, that's a fact. If all the commissioners are present and vote in favor, can you just put unanimous? You can, if all 5 are present and all 5 are present for the vote, and all 5 vote in favor, you can put the vote was unanimous. However, that's not enough, because it depends what you write. And here's the problem. You would have to write all 5 commissioners were still present, all 5 commissioners voted in favor. That's a lot of language, right? Because you have to recite that all 5 were still present. You need to know who is absent, not absent. So what you cannot do, which I see a lot, is the vote was unanimous. Now, what I've told people, because they fight me, I don't want to keep that little list, yes, no, abstain, absent. I said, okay, fine. Then put one line at the beginning of your minutes, if you so choose, and that will say, it's standard line, right? You'll never have to retype it because it will always be there. It says, unless otherwise stated, all commissioners in, I'm going to repeat this, unless otherwise stated in these minutes, all commissioners listed as present were present for each vote. Now, if you have that one line and only 4 commissioners show up, and then you put vote unanimous, now I've solved that issue, right? The vote was unanimous. All 4 present were and remained present. So you just have to make sure that you have some language that says, unless otherwise stated, all the commissioners were listed as present for the meeting, remained present for each vote. That's fine. So then yes. And again, it's a standard line. If you want to do that instead of the yes, no, abstain, absent, I'm good with that. You just have to know that somebody didn't leave, right? So somebody could say, look, I got up to go to the bathroom. You voted. I wasn't there. You can't list me as present. So that's important. Okay. You got 4 months to sue, generally, to overturn certain things. A bond, I get it down to 20 days to sue and to object. And bond counsel can do that with something called an estoppel notice, don't worry. But you generally have 4 months. Well, that's pretty dangerous, isn't it? You may not know for 4 months that you screwed this up, or somebody thinks you screwed it up. They file suit against you. You may have already done the act, and now you're getting sued for it 4 months later. Better to have attorneys review certain things you think are questionable. Look, attorney, I would rather be involved, and this is how I think you should use your attorney. I would rather be involved before than after. After, I will make 10 times the amount of money, right? Because that means you're getting sued or you're defending screwing something up. I would rather spend 1/10 of your money and we prevent yourself from getting sued or even losing a lawsuit. Lawsuits take forever, ever. There is no quick lawsuit. They take forever. They are expensive. They can cost hundreds of thousands of dollars. They do. So better you prevent it, right? Better you prevent it. Okay. Notices of meetings and elections. We've already covered this. I don't know why it comes up twice, but it does. Okay, that's open meetings law. Now let's do Freedom of Information Act, and then let's take another break. Fire districts have to abide by Freedom of Information Act. By the way, so do fire companies. Fire companies, just so you know, don't have to abide by the open meetings law, but they do have to abide by the Freedom of Information Act. Fire districts have to abide by both. What records have to be made available? Well, minutes of meetings, hearings, internal and external audits, financial records. Right? Now, can you redact some stuff? Yeah, I'm not going to turn over my bank statement with my account number on it, right? You can redact that, but yeah, bank statements maybe. Itemized records of the names, addresses, titles, and salaries of paid officers and employees. Paid officers and employees. If your secretary or treasurer or your volunteers are not paid, I don't think you have to turn over their names. Not that I ever would reject telling someone who the treasurer and secretary are, right? But I will tell you this. I have fought successfully so far. We'll see where it lands in courts. I refuse to provide the names of volunteers, the names and addresses of volunteers. I say the contact information for any volunteer is the firehouse. Why? I think it's a safety issue. It could be a terrorist issue, but I think it's a safety issue, right? And I sure don't want somebody pissed off. I had somebody walk in the firehouse when I think I was captain or third assistant chief, and their dog died for a fire I ran. And the garage was fully engulfed. I think I have the pictures probably. The garage was fully engulfed, and the father and the son run up, say, "Chief, you gotta save my dog." And I said, I'm sorry, if your dog's in there, we can't. I'm not going to send anybody in. You have to save him. I'm not. And I said, I'm not going to send anybody into that garage for a dog. It's not going to happen. Things were blowing up in the garage, cars, propane tanks. Not going to happen. It got very heated. 2 days later, the guy walks in and says, "I want to see your chief," right, meaning me. The person said he's not here right now and said, "Well, you tell him I own some guns." Well, please don't hand out my address, right? So I, for that reason and similar, am not handing out people's addresses. But it says paid officers and employees. Paid officers, you can give your names, the titles, but I'm telling you, your address, firehouse address. Okay. And I don't want to get too much off in this. You have to have an index, quote, reasonably detailed by subject matter of records which may be produced. What that means is have all your minutes in one place, your financial records in one place, right? Everything you've got to have in a place where you can easily find